Gerard Filitti is the senior counsel at the Lawfare Project. He's also worked in for more than 15 years. I'm not sure what that's saying right now, but Gerard, thank you for coming back. We chatted yesterday. We're here Friday after all of this, and we just heard Alex talk a little bit about what happens next now that all 19 co-defendants have been booked. But I want to hear your take from your perspective of what you anticipate to be happening here.
Well, what we expect now, first of all, we will see arraignments at the beginning of September. So the week after Labor Day, each of these 19 defendants is going to go into the courtroom to plead not guilty, guilty, or something else. So we will see Donald Trump, we will see Rudy Giuliani, we will see everyone else making a court appearance. And when I say we will see, the court has explicitly allowed cameras in the courtroom up until September 8th. This is likely to be renewed, but we know that cameras will be present. So this is historic. This is the first time we will see a former president of the United States stand before a judge and plead presumably not guilty in a criminal conspiracy case. After that, we will go into discovery, and after that, we will have pretrial motions, which will take a lot of time, and we will do a lot of reporting on to be sure before we even get to setting a trial date for other defendants.
Yeah. What is the possibility that some of Trump's co-conspirators could make a deal, and what might that look like here?
Well, that's always a possibility, and that is a stronger possibility when you consider that a lot of these trials are likely to be severed. We see Chesboro going first. He will be the first one to go on trial, presumably in October. What this means is that other defendants will have an ability to see the government's case, essentially, because a lot of what he is being charged with applies to every other defendant as well. So when you're sitting there, you can evaluate the strength of the government's case and, quite frankly, see what happens to Chesboro, whether he is found guilty, whether he cuts a deal. Your case is set for after that. You have a good incentive. If you're seeing a harsh penalty, if you're seeing that this man is found guilty, you have more of an incentive to cut a deal than to go to trial as well. So this really will be a test case that will send a message to all the defendants about the strength of the government's case and inform them on what the best course of action is.
Well, DA Fani Willis has said that she wants arraignments to begin the first week of September, on the 5th to be specific. Is that too soon? Is that a normal timetable? What do you make about the timing here?
Arraignments are normal. Arraignments are usually very quickly handled after arrests. That is your first appearance in court when you're pleading, when you're essentially saying, I'm guilty or not guilty. And that's when you handle a lot of other procedural matters. In Georgia, in this case, and in others, it's different because if you have a bail arrangement, as 18 of these 19 defendants do, you are immediately released from jail and your arraignment is set at a subsequent time. In other states, it's different. You're arrested and you have an arraignment much quicker after your arrest date. So this is very normal. Having it a few weeks after arrest is also normal. And really all this is an introduction to the defendants to the judge.
We were talking with Alex about Harrison Floyd, the one co-defendant who is in jail and was, denied bond. What do you make of that latest update?
Well, it's very interesting, and the question is, do we really know what other criminal history he has or what allegations are in his past? One of the conditions of being able to obtain bail in the first place is that you are not currently facing other charges, and that you are not currently involved in other criminal conspiracies or criminal actions. So we don't really know, at least I have not seen documents about his background and whether he is facing charges anywhere else that would preclude or make bail more difficult. At the same time, he could also be one of these people who wants to send a message and stand up for his convictions and actually be incarcerated rather than post bail. We just don't know yet, but these are questions that a lot of people are asking.
Yeah. Well, we've got about 45 seconds here. 3 defendants in the case have requested transferring their cases out of Fulton County. I actually think it may be a little bit more than that, maybe 5. But if one defendant is moved, wouldn't all of them file similar motions? And why would they want to move the case out of Fulton County?
Well, the main reason to file, well, there are 2 things that you can do to move the case. One is to remove it to federal court, in which case you go into federal court system and you get a different jury pool and you apply a different set of defenses. Essentially, this is a good strategy for people like Mark Meadows, who claimed that they were engaged in their normal course of business and were acting under the orders of the president, and they did nothing wrong. For other defendants, you want to move the case out of the county because you're also looking at a different jury pool. Quite frankly, this is a county that voted heavily for Joe Biden. And a concern that these defendants have is that they will have a jury of people who are disinclined to like them to begin with, and they want a better jury.
Gerard Filitti, Senior Counsel for the Lawfare Project. Thank you for joining me today. It's always a pleasure to chat with you.
My pleasure.